He strangled a woman while heavily intoxicated, and now a judge is warning him that one mistake could cost him his freedom, his firearms, and his entire future. But what the judge said next left the
possess or own a firearm.
Yes.
You would no longer be able to vote in any election until your civil rights are restored.
Yes.
Now, here, the state would have to prove for count 1, strangulation and suffocation, on or around November 23rd, 2025, in Burnett County, Wisconsin, you intentionally impeded the normal breathing by applying pressure on the throat or neck of another person. Do you understand what the state would have to prove?
Yes.
Do you understand for that Class H felony that upon conviction, you could face a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes.
As to count 2, misdemeanor battery, the state would have to prove the same date, the same time, the same place. You caused bodily harm to NS by an act done with intent to cause bodily harm to that person without that person's consent. Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Now, your attorney placed the agreement reached with the state on the record. Do you understand that agreement as it's been reached?
Yes.
Do you understand that I'm not bound to follow that agreement? That means I could sentence you all the way up to the maximum possible penalties for both of these crimes, and I'm not required to accept a deferred judgment of conviction. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
Did you go over that criminal complaint with your attorney, and in particular, a section called the probable cause section, where it basically says what happened that day and why you were charged with these crimes?
Yes.
For the most part, and I do understand that alcohol was an issue or involved here, but for the most part, are you admitting that the facts are accurate?
Yes.
Mr. Becker, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, as well as the preliminary hearing that was conducted.
Thank you. Are you pleading guilty to these crimes, Mr. Belial, because you are guilty of these crimes?
Yes.
All right. Now, has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the discovery and the evidence and discussed it with you?
Yes.
Have you discussed the facts that you know to exist with your attorney?
Yes.
Has he discussed with you a potential for any legal defenses or a lack of defenses?
Yes.
Have you discussed with him, again, any defenses that you believe could exist?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to count 1, strangulation, suffocation, a Class H felony, how do you wish to plead?
Guilty.
As to count 2, misdemeanor battery, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those counts. The remaining counts and any open matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered as to count 2. As to count 1, the court will allow parties to be heard. Mr. Schmidt, we are in victims' rights compliance, no victim impact statement to be made here today. So argument and sentencing recommendation.
Judge Alan Belial is a 44-year-old man with no prior criminal convictions. The only criminal history he has is in 2008 and 2010. He had DCs in Burnett. One was not violent. The other seemed to be a reciprocal event with a significant other, where reading the criminal complaint seems the other person initiated it. In this case, this happened many years later. In these circumstances, you can see the level of intoxication of Mr. Belial on the body cam. He was in a woman's room on her bed, and the officers took a great deal of time to even convince him he wasn't in his room in his house. That's the level of intoxication. He couldn't really stand or walk. It was troublesome getting him down the stairs at all. in Wisconsin, thankfully, we're a state where intoxication can't be a defense to criminal culpability, but it's incredibly relevant when figuring out the sentence, how to prevent it in the future, how to protect the public, how to make sure it doesn't happen again. That is why I've structured this as it is. The DJOC has the AODA requirement. That's 100% what's needed in this case. I think there's no doubt about it. This isn't a domestic incident. The victim doesn't even really know Mr. Belisle that well. She was just giving a friend of a friend a place to stay when he was clearly extremely intoxicated. There was no inciting incident. Essentially, he was there sleeping. He was so intoxicated, he got up, started hitting the wall. She told him to stop. He stopped once, did it again, came back. That's when he choked her. That's when he attacked her. The reason why we're still getting the conviction and doing the 10 days jail on this is because the way this impacted the victim is so severe. It's just necessary in this case. It's necessary that this be the first conviction for Mr. Belisle. It's necessary there's some incarceration. The reason she's not here today isn't because she doesn't care about the outcome of this case or didn't impact her enough to give a statement. It's because it impacted her so much. I won't go into the details, but she's affected emotionally and psychologically a great deal and still is to this day. That's what I'll leave it to on that. So I think that this accomplishes all the purposes of sentencing. I think that this accomplishes punishment with the jail sentence and not depreciating the seriousness of that with the jail sentence in conjunction with the conviction, the first conviction he has. So going forward, somebody asks if you've ever been convicted of a crime. The answer is now yes. And then also the DGOC making sure that we accomplish the rehabilitation and public protection objectives by making sure this doesn't happen again. It was obviously caused by alcohol. He had no motive to attack her at all. So I'd ask the court to follow this agreement. Thank you.
Is that why restitution is, one reason why restitution is being held open? Is she seeking any kind of trauma services?
No, the restitution is immediately after this. She was affected so much emotionally, she couldn't go to work for the week afterwards.
And that was around Thanksgiving, if I'm recalling.
Yep.
correctly.
So she gave us the time card, which shows the time they did pay, but we need the work schedule to show she was actually scheduled to work there. So I didn't realize that until Mr. Becker emailed me, and it was too late to get that from her today.
How, in the state's view, will Mr. Becker have the oversight to control his alcohol intake with the DGOC?
Mr. Belisle.
Oh, sorry. I'm sorry,
You're
Mr. Becker.
Totally good. Just wanted to
BBs.
make that clear.
No,
100%.
I'm totally okay with your alcohol intoxication, but Mr. Belisle, I'm sorry. With the deferred judgment of conviction, what oversight is there going to be to ensure that he is not only getting that AODA assessment, but that he's controlling his level of intoxication?
Well, the AODA assessment, there's benchmarks in the DGOC by when he has to do the assessment and do the treatment, provide proof to us. So if he doesn't do that, I mean, it's on him to prove that to us. So that would trigger a filing of a motion to revoke the deferred judgment conviction. If you're asking if there's any testing built into it, there isn't anything like that, no.
All right. And is there absolute sobriety in the deferred judgment?
I believe it's a condition of bond. So I didn't put it as that.
All right. I'm gonna pull up bond. There is an absolute sobriety condition. There would have been in that he would still be under bond for a period of 12 months. So, all right. Mr. Becker.
Thank you, Your Honor. I agree largely with the context and the things that DA Schmidt has said. Mr. Belisle is 44 years old. He works for Zeman Construction as a field superintendent, so he's employed full-time gainfully. He supervises construction projects, loose term, in the Twin Cities metro area predominantly, but it spans on this side of the river sometimes too. As DA Schmidt indicated, he has no prior criminal record. There are the two things that are quite dated, 08 and 2010, which didn't result in any criminal convictions. The incident here is outlined in the complaint as reflected in the body cam. There's no question that alcohol was at play. In addition to that, Mr. Belisle was taking a medication in a new dosage, and so there was a mixture that he hadn't experienced before.
What medication? There was nothing listed on the plea questionnaire.
At the time, not now.
Not now?
He's not taking it now. No. And so, and it wasn't for a mental health issue or anything like that. But I believe because of the dosage and the amount of alcohol that was present, there was an interaction which he hadn't experienced before. As a threshold issue, the amount of alcohol present was high in and of itself, right? And so obviously not an excuse by any means, just factually what happened here. The facts as they exist, which led to what happened. The agreement that's been structured, the agreement that he's accepted, has him taking responsibility for his actions that night at the most severe charge that he's charged with and at the second most severe charge that he's charged with. I think it is a measured agreement in terms of what is required of him. I have always described DGOCs as probation light to people. It's the same thing. You have conditions you have to follow. If you don't follow them, you get in trouble. That's what happens on probation. The difference here is you're betting on yourself. You have something at stake, and that is not being a convicted felon, which is a high benchmark for somebody who today, as he sits here, is getting his very first criminal conviction on a misdemeanor battery. And so Mr. Belisle is betting on himself to be successful, to do what he needs to do in order to demonstrate to the DA's office and to this court that he is a quote unquote healthy and productive member of society, and that what was outlined in this complaint as of happening November 23rd, 2025 is not his normal, nor nowhere near his normal. It's an anomaly, a big one at that, a severe one at that. No one discredits that. No one argues that. I think pairing the DGOC with 10 days jail is the carrot and the stick, right? Case law tells us that probation is the first thing that you look at. That's why I referenced the DGOC being probation light. We can call that good right there on the DGOC. And then we're looking the next step further on the jail, right? It demonstrates to Mr. Belisle what happens if you're not successful. Because if he's not successful on the DGOC, he's likely, the state will do what the state needs to do. He comes back in front of this court for a sentencing hearing where anything is fair game, probation, jail, or prison. It's all there. And as a former ADA, now defense attorney, I've seen many of those. And we can all agree that probation is a tough sell on the revocation of a DJOC. It's not impossible, but it's a tougher sell. So the jail is kind of a warning shot across the bow, so to speak. Overall, I think this is an appropriate resolution when we look at the facts and the circumstances. This incident clearly demonstrates through the videos and the testimony, Mr. Belisle was not in a headspace where he was interpreting things appropriately or positively or accurately. He was not the most cooperative person in the world with law enforcement. It's because of how intoxicated he was. Again, that's not going to fly to 12 members of this community, but that's the underlying issue. So we address that through the AODA, and that will hold him responsible. I did forget to mention this off the top, and I apologize. And it goes to the conversation we've been having about bond. I 100% agree that the absolute sobriety condition should exist. We do not argue that should come off. I only wanted to discuss the following condition, that he can't go to any bars, taverns, or pubs. One, from a work perspective, he may have to work in those areas through his construction job. And two, he runs a volleyball league in the summers at Wood Hill Bar and Grill out of Osceola. He'd like to keep doing that. He plays in it. He runs it from a logistics standpoint. Now, the interplay of that is we understand alcohol is an underlying issue of what happened here. He understands that by making this request to the court, he's basically putting the court and the DA's office on notice that if you grant that request, he's going to be at that bar and grill for this volleyball league. So,
or he misses it for a year.
That too. I just mean if you grant it, people's instincts are up. They know what he's doing. There might be more oversight as it relates to that, right? And so he's confident in his ability to withstand any pressures or any inclinations. Also with an AODA and whatever treatment comes with that, will help him through that to be sober, stay sober. And so that is another request that we wanted to make from that aspect. But overall, that is my argument, Your Honor. I'd ask that you adopt the joint recommendation, as I believe it's appropriate and measured here.
Thank you. Can you repeat what he does for work? Because you said he goes on the other side of the river.
He's a field superintendent for a construction company. So he, I think we can liken it to a project manager, foreman type. He's overseeing these
But
jobs.
he's the boss.
Yes.
On site, yes.
Okay, so you're not doing the construction unless you're showing them how to do it?
Yes.
Okay. If you have an ability to be somewhat flexible in your job?
My understanding, and he can verify, is that he's assigned job duties or locations to do projects. He doesn't get to do the assigning of the ones he goes on.
No, okay, but if do you have a flexible week where you could say, I'm gonna be honest, I'm gonna be telling you, I'm contemplating adding a requirement to the deferred judgment of conviction to do one of our restorative justice programs. Because I think it will help you, not only with what happened, but it will help you for the future with the unknown that the court has.
This courtroom hearing started with what looked like a standard plea deal, but within minutes, the case took a serious emotional turn. A 44-year-old construction supervisor stood before the court facing felony strangulation and misdemeanor battery charges after an alcohol-fueled incident that prosecutors described as violent and deeply traumatic for the victim. According to prosecutors, the defendant became so intoxicated that police officers reportedly struggled just to convince him where he was. What began as a night of drinking allegedly escalated into violence after the victim asked him to stop hitting the walls inside her home. The state made it very clear this was not just another drunk incident. Prosecutors explained that the victim was still emotionally affected months later and was too traumatized to even appear in court for the sentencing hearing. That detail immediately changed the tone inside the courtroom. Despite the seriousness of the case, both sides reached a plea agreement. The defendant agreed to plead guilty to felony strangulation and misdemeanor battery. In exchange, the court would allow a deferred judgment on the felony charge, meaning if he followed every condition perfectly, he could avoid becoming a convicted felon. But there was a catch. The judge warned him that even one mistake could destroy that opportunity forever. If he violated bond conditions, drank alcohol again, failed treatment, or committed another crime, the felony conviction would immediately be entered against him. The judge repeatedly emphasized how serious that would become. At one point, the judge directly asked the defendant about his relationship with alcohol. The defendant admitted things could spiral out of control on certain nights, though he denied having a major alcohol problem. Still, the judge wasn't fully convinced. Instead of simply sentencing him and moving on, the judge added something unexpected: restorative justice coaching and a mandatory apology letter program. The judge explained that the goal wasn't only punishment, it was making sure the defendant truly understood the emotional damage caused to the victim. Then came one of the courtroom's strongest moments. The judge reminded the defendant that he now had a criminal record and warned him that losing control again could cost him his hunting rights, firearms ownership, and potentially years in prison. Even the defendant's volleyball league became part of the discussion. The court agreed he could still participate, but only under strict no-alcohol conditions.
Lose if I don't. And yeah, I just apologize to everybody involved about the whole thing.
So, Mr. Belisle, prior to this incident, would you say that you had some issues with alcohol? Let's be fair. I know a lot of construction people, and I know that some of them like to partake.
A problem? Honestly, no. I don't drink if I have to work the next day. I only have some socially on the weekends. No, but they're not hard for it to spiral out of control on a given night.
It could spiral out of control?
It wouldn't take much.
Okay.
Not that it's happening often, but
Okay, sorry, I'm just writing something. Anything else you want me to know?
Not at this time.
All right, thank you. Um, What I get to know about the case is what is in the criminal complaint and what the individuals tell me, or what impact statement I hear from any victims involved. So what I have in front of me is simply what's stated in black and white in the criminal complaint, again, with the arguments. I think everybody here admits, even you, Mr. Blisle, this was a very serious matter. And it rose to a level of violence. Maybe that's in your nature, maybe that's not in your nature. I don't know you again from Adam. This is the first time I've seen you. You're from Osceola, you're from a different county. But from your criminal history, which is very sparse, it appears that you follow the law, or you usually do what you need to do, and or you haven't gotten caught. But if it relates to violent episodes, other than the ones that were from 08 or 10 or whatever those are, Mr. Schmidt, the state's not even saying that they were extremely serious. There's something to be concerned about. This looks like it could be a pattern, and it could be hidden from 2010 to 2026. So I'm not getting that as an argument from the state. I could be, but I'm not. So I'm not going to define anyone who's in the contract or construction business. I know plenty of people, family members of mine are, but I do know that sometimes after a job or after a night, and especially if you're out of town and your house out of town, generally people go and they have a few beers or they have a few more. I don't know if you do have an alcohol issue. You did make a statement that at times you could, I don't remember your exact words, it can get out of control or get out of hand. Thankfully, it has not gotten out of hand to this level before. Otherwise, this would be a different outcome. But again, this is a serious matter. It's so serious, and it was so impactful to the victim that she can't even appear here today. For fear, I'm guessing, that it would cause her anxiety to go up, all of these emotions, just from hearing what's going on, and probably from the sight of you. That makes this extremely serious, and that makes the court have to look at this a little bit more carefully. You are accepting responsibility and you are willing to be accountable. This is a crime. You're 44 years old, and now you are a convicted person. You have a criminal record. You can't get this expunged off of your record. It will be there, and it will be there as a battery on your record. There are certain requirements in the deferred judgment of conviction, and that is an additional oversight. It's not as stringent as probation. There's pluses and minuses to deferred judgment of convictions, because they are serious enough and they do have enough oversight that if you do not abide by your bond conditions and or you commit any crime that rises to the level of probable cause, or you do not do your AODA assessment and provide proof to the state, and or you don't pay your $150 within 60 days, a felony can be entered on your criminal record. It could be the agreement can be revoked and terminated, and judgment will be entered, and you will be in front of the court for sentencing on a felony, and you will be a convicted felon. That's what makes this a little bit more of a stick over your head, because I think I'm gonna guess, I don't know, you like to hunt.
Yes.
Yes. And it would be a serious penalty to you to have your firearms taken from you forever.
Yes.
And so knowing that and knowing that you are under your bond conditions, hopefully that's enough for you to abide by the law and do the things that you need to do and follow the law to the letter instead of walking that gray line. Because not only will you lose your firearms, you're going to be a convicted felon. You could go to prison because it's a Class H felon. Serious. Now, for the most part, I do think that the agreement is appropriate. There's going to be punishment with jail. Nobody likes to go to jail, especially an individual who, other than these 2 days, I don't know if you've ever been in jail, but that's going to be the longest time that you're going to be in jail, hopefully for the rest of your life. That's punishment enough. Can't order Diet Coke. You can't order a steak. You're stuck with whatever food they have and they give you and the packet of lemonade. Okay. So that's not going to be fun. And I believe that will give you time to reflect even more on this incident and what happened. I'm going to accept the deferred judgment of conviction because it is something that is serious and you could be a convicted felon if you don't abide by those things. I am adding the condition though, and I'm going to write it right on there that you do the apology letter coaching and you write an apology letter, whether or not she wants to receive it, because she has the choice where she doesn't even have to even open the envelope and read it. That could be traumatizing for her, but at least there, if that happens, she would be able to hear your remorse and anything that you want to say and apologize. So I'm going to say that you do the apology letter coaching with restorative justice. And at the same time, you do the skills directed practice. In skills directed practice, that's where you can meet with Mr. Hatch and he can talk to you about any resolution skills that you have, cognitive awareness, thinking before you act, and possibly thinking before you have the third beer or fourth beer, or even the first beer, quite honestly. And it is a program that will restore your relationships. You'll get an idea or understand the impact of the victim, and you'll be able to think a little bit more about that. And it's there so you can have a better understanding so that you can, when not extremely intoxicated, you can respond to things that happen in your life instead of reacting. And I asked your flexibility with work because this is a 4-week program. And the apology letter coaching can be built right into that. But I am going to say that Mr. Hatch can be a little bit more flexible and that you can work it out. So even if it takes 8 weeks, it takes 8 weeks. The important thing is that you do the class, you learn the things, you speak with Mr. Hatch, who is a previous probation officer for over 20 years. And now all he does is restorative justice, which is trying to restore. It does a whole lot of good things for the community, for people who are in your seat, as well as for victims. And so I love the restorative justice program, and Mr. Hatch is really good at what he does. And I think you're going to find him to be a really good person. And you can probably talk to him about a lot of life things. So I'm going to say that that needs to be completed. If this is going to be a year, I'm going to say within 5 months. But you do have to contact Mr. Hatch. Today is Wednesday, and at least leave a message for him by the end of the week and have him try and connect. And you can talk to him and you can say the court said this can be flexible, but he's going to get my document that says be flexible. You're going to get a copy of this too. So by August 31st.